we know that the all-important verdict that came out from the Supreme Court today was a split verdict. There were two different judgments given by two judges on the bench that was hearing the case against disallowing hijab in the premises of schools in Karnataka. My colleague Pranesh now joins us for more details because Times now has accessed the entire judgment. Over to you, Pranesh.
Voluminous document, Priya, to be specific, 209 pages, accessed by our legal editor Harish Nair. Like you said, this is a split verdict that we are looking at, and I've been told that the operative part begins from point number 47. I find that the state government has the power to constitute a college development committee by the notification dated 31st January 2014. This is now talking about what happened in the Karnataka High Court. In fact, let me stroll down to point number 82. Point number 82 is, this is 93. Just give me a minute. I'll read out point number 82 because if you see the kind of reactions
Pranesh,
which are coming in already.
Have it. Let me just run our viewers through the beginning of point number 82 and then you can go to it. It says our constitution has visualized a just society, and it is for this reason that the first virtue that secures for citizens is justice, which is the first of our preambular promises. Remember, this is the judgment that has been given by Sudhanshu, Dhulia, and by asking girls to take off their hijab before they enter the school gates, he says, is first an invasion of their privacy, then it is an attack on their dignity, and then ultimately it is a denial to them of secular education. These are basically also the three main arguments, Pranesh, that were pointed out by the petitioners in favor of hijab. It's over to you if you found the operative parts.
Says that further in the A.S. Narayan Dikshitulu case, the court held a religion undoubtedly has its basis in a system of beliefs and doctrine which are regarded by those who profess religion to be conducive to the spiritual well-being. We are not taking a break, staying on this story. Every religion must believe in a conscience and ethical and moral precepts. Therefore, whatever binds a man to his own conscience and whatever moral or ethical principles regulate the lives of men, believing in that theistic conscience or religious belief, that alone can constitute religion as understood in the constitution, which fosters feeling of brotherhood, amity, fraternity, equality of all persons, which find their foothold in secular aspects of the constitution. Then another case been quoted here, Sri Adi Vishweshwara of Kashi Vishwanath Temple, Varanasi versus the state of Uttar Pradesh. This court held that the religious freedoms guaranteed by Article 25 and 26 is intended to be a guide to a community life and ordains every religion to act according to its cultural and social demands to establish an egalitarian social order. Article 25 and 26 therefore strike a balance between the rigidity of the right of religious belief and faith and their intrinsic restrictions in matters of religion, religious beliefs, and guaranteed freedom of conscience to commune with his cosmos, creator, and realize his spiritual self. Point number 85, and Harish Nair, our legal editor, is also joining us, Priya. I will toss to him after this reading point number 85. Thus, religion believes in conscience and ethical and moral precepts. The freedom of conscience is what binds a man to his own conscience, and whatever moral or ethical principles regulate the lives of men. There is a fine distinction between freedom of conscience and religion. The scope of protection under Article 25 goes beyond religious beliefs. This provision affords to all persons freedom to beliefs which may not necessarily be religious, but which may spring from one's conscience. Freedom of religion, on the other hand, grants one the right to follow one's faith, the established form of which gives a set of ethical norms to its followers and defines rituals, observances, ceremonies, and modes of worship.
Right, Pranesh, you are taking us through the observations that finally led to the conclusion that was arrived at of Justice Sudhanshu Dhulia. Harish Nair now joins us. If you could just tell us what were the main arguments that were made by Justice Hemant Gupta. Harish.
Yes, in fact, as we know, Justice Gupta has upheld the ban and Justice Dhulia has struck it down.
Yes.
And now we have the story as to how they managed to arrive at a split verdict. And now it says that Yes, the judgment shows that the two judges in the bench have differed on all three main aspects. That is, number one, if the wearing of hijab is an essential religious practice. Number two, rights of institutions like colleges have primacy over individuals' freedom of expression. Number three, if government has the power to pass the government order and therefore is there a ground for invalidation. So on all these three grounds, there is a divergence of views between Justice Hemant Gupta and Justice Sudhanshu Dhulia, and Justice Gupta upheld the Karnataka government circular and dismissed the appeals against the Karnataka High Court judgment. However, Justice Dhulia has allowed all the appeals and set aside the judgment of the Karnataka High Court. And so, see, one of the most biggest difference is on the essential religious practice. Justice Hemant Gupta has ruled that wearing of hijab is not an essential religious practice of Islam, and requirement of uniform is a reasonable restriction on the fundamental right to freedom of expression under Article 19(1). He ruled that government has the power to pass the government order and therefore no case is made out for its invalidation. Very, very significant. And at the same time, Justice Dhulia is of the view that Karnataka High Court could have avoided going into essential religious practices, and that too based on commentaries and interpretations of Quran, even term paper, research papers of a student, and not the original verses of Quran. Justice Dhulia goes on to say the main thrust of his judgment was that the entire concept of essential religious practice was not essential to the dispute, and the High Court took a wrong path. It is a matter of choice, nothing more and nothing less. Very, very significant observation from Justice Dhulia, differing from Justice Hemant Gupta, and therefore he says, I have quashed the government order of February 5 and has ordered the removal of the restrictions. And Justice Dhulia goes on to say that what weighed on my mind is whether we are making a girl student's life better by putting such restrictions when her education is concerned. The High Court took a wrong path. It is ultimately a matter of choice, and Article 19(1)(a) and 25(1), it is a matter of choice, nothing more and nothing less. Foremost question on my mind was the education of the girl child. Are we making her life any better? So, Priya, the two judges have differed on all these three main aspects of this case. Number one, if the wearing of hijab is an essential religious practice. Number two, rights of institution, the power of an institution to prescribe an uniform versus hijab. Number three, if the government has the power to pass the government order and therefore is there a ground for invalidation.
Right, let me just take our viewers through what Justice Hemant Gupta said on the point of uniform and whether the colleges can decide on it or not. He says the government order dated 5th of February contemplates that the prescribed uniform should be followed. It necessarily excludes all religious symbols visible to naked eye. The argument that the students wear Rudraksh or a cross is mentioned only to deal with an argument so raised. Anything worn by the student under his or her shirt cannot be said to be objectionable in terms of the government order issued. Harish, tell us the significance of this observation.